Hi, welcome to Youth and the Law. My name is Carissa, and today we'll be speaking with Robert. Robert is a lawyer in the Regent Park area in the Daniel Spectrum building, and today we'll be speaking about copyright laws. So, what are the moral rights behind copyright laws?
Okay, well, copyright is something that anyone who creates anything, they have automatically. You don't have to do anything to assert a copyright. But there are a bunch of different parts to copyright. Like there's the copyright in music, copyright in images, copyright in text. Anything that you put into a form, basically an artistic form, then becomes copyright. And it's the exact form that is the copyrighted part. So if it's changed in some ways, then it becomes something different. So moral rights are a different part of copyright, a more subtle part of copyright. And that's a part that protects the artist from the use of their work in a context that would change its meaning. In other words, usually that it would diminish its meaning or make it seem superficial. So it's something which underlies the basic copyright, the copyright in the form and the right to copy. Like that's literally what copyright means. It's the right to make copies of a thing. So, but moral right isn't really about the right to copy it. It's really about the right for a thing to have the meaning that the artist wanted it to have in the beginning.
Okay. Why should this be important or relevant to the youth?
Well, I think the best way to talk about that is through examples. So there was a situation. There was a situation in Canada where moral rights were invented, basically, because they didn't exist before this case. And you'll be able to cut away to the picture of everyone knows the Eaton Centre. You know the Eaton Centre.
Yes.
And in the mall, there are these geese at the south end that are suspended from the ceiling. And that's an artwork by a Canadian artist named Michael Snow. And it's a pretty interesting artwork because he carved the geese. He had the geese carved. I don't think he did it himself. He had somebody do the geese for him. And then he took photographs of geese and he pasted the photographs onto the carvings of the geese. So they look like real geese, but they're actually photographs of geese. So it's kind of a cool artwork. A lot of people don't know that about it. Anyway, what happened was that the Eaton Centre, it was Christmas time, and the Eaton Centre decided to tie ribbons on the necks of all the geese. So Michael Snow saw that and was really outraged. He didn't think that that was a very good use of his artwork. And so he complained to them, and they said, well, we can do whatever we want. And he said, no, you can't, and he went to court. And the court decided that there was this underlying right to copyright, which is the moral right of the artist to have their work presented in the way that they intended. So after that, the Eaton Centre had to take the ribbons off the geese.
So in other words, youth this is a way for youth to protect themselves as well.
Yes.
Against other outlets that would probably use their work.
Yeah, like it's a little bit hard to imagine when you're a creative artist. You're doing stuff and you're so anxious and eager to get it out there for people to see it that it's hard to imagine a situation in which it could be abused. Like, what's going to happen? But another good example is, do you know the band Parachute Club? Lorraine Segato is the artist in residence at the Daniel Spectrum building, and she had a band called the Parachute Club in the 80s, and she did a song called Rise Up. Her recording label, EMI, owned the rights to it along with her whole portfolio of songs. And so this was 1980 something, 3, 4, 5. And then in 1998, they were approached by McCain's, the fast food company, the French fry company, that had a new pizza dough, and they wanted to use the song as the song for a commercial, a TV commercial. which they did. And so Lorraine was sitting at home one day and saw her song being played on a McCain's pizza dough commercial. And she got really upset because she felt like, well, that's not what the song is about. It's not about a commercial product. In fact, it's the opposite. It's about protest in a way, right? Okay. So she brought it up with EMI, and EMI, sort of like the Eaton Center with Michael Snow, said, we can do whatever we want because you gave us the rights. And she said, no, actually, that's not true, because the moral right, even if you sign over your rights, your copyright to someone else, like a recording company, or an art producer, say, that they're going to do posters and stuff. You could give them the copyright, but the moral right is something that you can't sign away. Okay. So she brought it up with EMI. Again, there was a court case, and they settled it. And as a result, she got all the rights to all of her music back from EMI, which is pretty cool.
Wow, that was amazing. A lot of youth use YouTube as well as other social medias. We were wondering, what is the difference between watching a video online and downloading a video?
Oh, boy, I was really hoping you weren't going to ask me that question. You know, if something is on YouTube and it's on the internet, then you have to assume that it's there with permission. And if it isn't there with permission and someone complains to YouTube, then my understanding is that they will take something down. But they kind of have to be asked, because they can't possibly monitor everything that's thousands and millions of videos that are being uploaded every day. So you make an assumption when you're viewing it that you have a right to view it because it's on YouTube. But downloading it is sort of another aspect, because it's a different situation, because then you're actually making copies of it to use in another way. So really you should, technically, legally, you should be asking for permission to do that. We know that people don't. And you know, for the recording industry and certainly the music industry, that's very problematic. They would like everyone to pay for everything all the time. But really in today's day and age, it's almost impossible for them to keep track.
So we're going to switch topics a little bit up now. So
how are we doing?
Can you copyright names? Is that legal? Are you allowed to copyright names?
No, it's an interesting thing about copyright is that there's no copyright in titles. So you could have a book that is, then there's a movie, and then there's a work of art, and then there's a song, all of which have the same name, and they can't really complain about that. I'm not quite sure why that is. It's just sort of one of those interesting things. I guess because a title is not a form in a way. You know, it's not like a certain arrangement of colors on a painting, or a certain order of words in a poem, or a slogan, or an advertisement, or something like that. So a title is just a title. So there's some latitude there. So, but nevertheless, there are rights, or there is a kind of a value within titles that needs to be respected, or that kind of can become kind of a problem if you play too fast and loose with titles.
What about brands? Like, I know, for instance, say I had a clothing brand and you had a clothing brand, can they be of the same name, or can you copyright the name of your brand?
Yes, well then it's not really called copyright anymore, then it's trademark. So a trademark is a different legal setup, and you do have protections over names. Anything that is distinctive and unique and that you're using. It doesn't work like copyright in quite the same way, because it's not as automatic. There's actually a formal process for registering trademarks with the Canadian Intellectual Property Office. And you do have some protections there, because if you find someone who's using your mark, then you can make them stop. So that's also true with copyright. Someone is stealing your stuff, you can also make them stop. But a lot of times it depends on who has the best, the deepest pockets, and can afford to do the work necessary to make someone stop using your stuff. Yeah.
So how does one create a copyright? So where would you go? Where would you have to go in order to create a copyright for yourself?
Well, copyright is automatic. You don't actually have to do anything for it. You can register a copyright with the Canadian Intellectual Property Office, which is a part of the Canadian government. It's not too expensive to do that. But as I said, with copyright, you don't actually have to register it. With trademark, you also, there is a kind of informal trademark if you're using a mark. You can always, if you find someone else using it, you can always say that you were using it first and sort of claim some rights to that. But if they've registered the trademark, then there's a presumption that they were there first and that they have the right to use it. So if you're developing a new product and you're, let's say, doing t-shirts or jewelry or whatever it might be, you may want to trademark the name of your brand. To give yourself that benefit of extra protection.
Okay, great. So what about the use of names in Regent Park? Can you inform us about the history and the usage of the names in Regent Parks and St. Bart's Church in the community?
Yeah, I brought in some pictures which you guys can cut into later. Anyway, of St. Bart's Church, which is just down the street from Regent Park Focus. And the reason that I brought it in is because there's like the church, and then there's a new condo, which is part of the Daniels development of Regent Park, that's going to be right on the next block over, that's called the Bartholomew. So the Bartholomew, so for them to use the name Bartholomew when there's a church right next door, I thought was kind of interesting. And they absolutely have the right to do it because, of course, it's a name, so there's no real rights in it. It's not like the church trademarks the names of its churches or the names of its saints even, right? So it's kind of an interesting, I think the question is kind of whether or not they're trading on the name, like if they're taking some value away from the church in a way, an economic value that the church might have to exploit the name. Exploit in the sense of not take advantage of, but to realize the value of. Say you have a product, you want to exploit its value. Mm-hmm. So the church has definitely got a reputation within the community and is known as St. Bartholomew's. But now when people talk about Bartholomew, that it's also going to refer to the condo development next door, right? So it's a little bit of confusion in the marketplace. And also just a kind of a disillusion or dissipation of the value of the name.
Right. Can you just tell us a little bit about Daniel Spectrum and its relation in the development to Regent Park?
Yeah, we were talking before we started about Regent Park, and I was talking to somebody who used to work in housing, who's now retired, and I told him that I was working in Regent Park, and he said that he thought it was too bad that they didn't change the name when they redeveloped Regent Park. And I thought that was really curious because it never occurred to me. I like the name Regent Park personally. I think it's just fine. But for him, as an outsider, he doesn't even live in Toronto. The name is associated with, poverty, social housing, trouble, blah, blah, blah. And so he feels, his feeling was that there's a certain kind of stigma that's going to carry over to the new development just because of the name. And that, and whether or not you agree with that, it sort of brings up an issue, a kind of interesting question about what is the name of a neighborhood and who owns it. So Regent Park was named after Regent Street and Park Street, although I've looked at the maps and I can't find a Park Street. Is there a Park Street nearby?
Not that I know of.
Yeah, so I don't know, it's really weird. Maybe it was a street beside Oak, like Oak and Park, I don't know. Anyway, apparently it was an intersection and that's how Regent Park got named. Originally the neighborhood was called Cabbagetown, which I didn't know also. And that name got appropriated by the part that we now know as Cabbagetown, which used to be called Donvale, I think, because of the Don Valley. So that neighborhood appropriated the kind of cool name of Cabbagetown for itself, and then when they redeveloped Regent Park in the late 1940s and 50s, they came up with the name Regent Park. And I have no idea how they came up with that name, but it's obviously it's stuck, and it's what we have. The Daniels Group, of course, is branded all through Regent Park now because they are the developer. So they are the big investor here, and pretty much everything that you see, all the advertising and promotions and you know, the billboards for the new condo developments, and they're also a big supporter of a lot of the community work that's done here, including at Daniels Spectrum. So they're a sponsor for many organizations, so you also see their brand there.
Thank you so much, Robert, for coming in and sharing all your knowledge on copyright law. We look forward to having you here again. Your knowledge was greatly appreciated. Thank you so much.
Thank you. It was fun.
To the audience, thank you so much for watching Youth and the Law. We look forward to seeing you again next time.